One. Hmm. I have no one on my docket, so here so far. So, okay, let's just begin by letting everybody in. Good morning.
Good morning.
Thank you. I'm Judge Person. I'm going to mute everybody because it creates feedback on my side of the docket, but I will unmute you and it's under your control, but I just ask everybody stay unmuted till it's your turn. I want to just first apologize for the late start. I had some trouble on my side, and I appreciate your patience with that process. And with that in mind, though, I'm going to start. I did notice as people logged in, I want to go ahead and ask Mr. Matson to introduce himself. Mr. Matson is the prosecutor for the city. He is on the other side if you are contesting your case. And just remember that on the contested docket that we have today, this is a convenience to be on Zoom. It's helpful, and I'm trying to keep it alive. But please just note that if you would prefer to be in here for this particular hearing, if you would prefer to be in the courtroom, we can reschedule and do that here. I'm going to assume that it's convenient. Everybody's okay with this. We're checking in on cases. We're seeing which direction they're going, and why make that harder than it needs to be, especially for identified people who, there might be an issue with getting here. So I just want to keep that open and tell you that it's an agreement. I'm assuming that agreement by your continuing to participate. If you're not able to continue, or you just would prefer to be here in the courtroom to do your hearing, that's fine. And just let me know and I'll reschedule the hearing. So first, Mr. Matson, please introduce yourself.
Morning, everyone. I'm Ryan Matson. I'm the prosecutor for the city of Temple.
Thank you, Mr. Matson. And again, I'll just say that, I'm Judge Person. And Mr. Matson, I'm going to go ahead and kick off your meeting with, I did notice as folks logged in, you and Mr. Swain are going to go ahead and visit quickly and then come back into this room, this part of the meeting or room. And I'm going to just clarify quickly who's here. I see a few people here, and that's great. I just want to check if Jakaria Adams is here by any chance. Did I miss that you were logged in? The other person is Janaea Warren. Those are folks on my portion of the docket that I just wanted to visit with today. Everyone else is here to talk with Mr. Matson, and we're going to do that. But a few things that I think are important, helpful to note as you're moving forward with a case in a municipal court. I think everybody knows this, but the prosecutor, Mr. Matson, and who just introduced himself, he is not my employee, and he answers to the state of Texas, but he answers to really the city attorney's office. He is kind of the equivalent of a district attorney at the city level. Municipal courts handle Class Cs. This is a Class C courtroom. And we do all the code cases in town. We do all of the traffic codes that happen in town, accusations on the traffic code, animal services code, anything out of the city ordinance and state law that designates a Class C. Okay, so that's one thing to just take note of. Another thing to remember is that he is not your representative. He represents the state. If you desire or wish to employ an attorney in the Class C level in Texas, you're not court appointed an attorney, but you can get a reset of your case if you wish to consult with an attorney to get legal advice. You just say, hey, Judge, I need some time. And that doesn't mean that you would come back having hired someone. You could potentially hire someone, you might not. It doesn't obligate you to do so. So just know that doesn't mean that now you have to go hire someone. But, there are attorneys who meet with folks for free consults. And sometimes that's a free, thing if you need legal advice and you want to see if someone can benefit you, by the hiring of that person. Also, if you're on the not guilty docket, which is everybody right now on this particular screen, haven't yet formally accepted your plea. And so you have an opportunity, you still have time to do that. So just note that. And the way that you do that is go, Judge, I need time. And if you need time, I will most likely grant it. We just work with where we are. Now, another thing to understand is that ultimately, right now, I'm assuming that the cases that are moving forward at this time on this particular show of docket, that folks are contesting their charge, and you don't have to give a reason to me or to Mr. Matson. You may choose to discuss your case with him or not. I have asked him to please take note and make a decision as to whether or not he'll be able to announce ready for trial if he anticipates that he can do that, because that is the task of one of the tasks of a prosecutor. And so I've asked him to take that seriously now so that he can give you that answer, and to review his side and see if there's anything that needs to be done prior to trial so that we don't hit any hiccups when we get to trial. I also would respectfully ask you to take your case seriously. Obviously, you have, or you wouldn't be here. Also, if there is anything that we need to address procedurally prior to the trial, and when you ask me what is procedure, procedure is how things move through a court, but they're not really content related, with some exceptions. They're not related to what may or may not have happened, but to how are we going to proceed in the courtroom. And I can't give legal advice about that, but if you have things that we're going to need to address beforehand, it's a good time to mention it so that we schedule trial and you don't come over here and hit a hiccup and have to keep coming in. Okay. I'm not seeking to make this harder or longer, but we do have to respect what the law says we are to be doing in court prior to trial. So a few things just to take note of in Texas. Well, this is pretty true across the board. If the burden of proof is on the state to prove the case first. When we get to trial, that's a requirement. But what I will say is at the point of trial, we don't then stop and you go get ready. At the point that if they have made a showing of the elements of the accusation, then we move, then it's your turn. And if you want to, at that point, ask questions of any of his witnesses, you'll be able to do that. And, we'll go from there. It just kind of goes back and forth, turn taking. The rules that we use here are the Texas Rules of Procedure. And also the Texas Rules of Evidence. Those are online. I think we have a link on the city website. I'm pretty sure we do. And you can click and go look at those and see, and think about how you might be presenting the information that you're trying to get forward. I am going to talk in a quick moment about ways to how the dismissal options that we have in this court. Mr. Swain, I think Mr. Matson will be back over here in a quick moment. And I will tell you that I'm just pulling up the files that are related to your clients. So give me just a quick moment here. I know we have Grant and we have Ho. Mm-hmm. Brubaker. Okay, and also with Brubaker, but I'm just saying, I think Mr. Matson's made it back over. Good.
Yes.
Okay.
I have a client named Morgan as well, Judge. I'm not sure if you have that file.
Okay, let me look. Yeah, I have it down. I forgot to mark it. Give me just a second. Thank you. Okay, let's see. Give me 1 minute. I've got everything spread out. On Brubaker, I see an agreement before the court of
Yes.
a deferral that is running for 120 days till November 5th, I believe. Let me look. Yeah. Can't believe we're gonna already be that all the way into November
Mhm.
that soon. Okay. There's going to be a record that is produced by the 60th day and payment by the 30th day. Mr. Swain, is that your understanding on that agreement?
It is, Your Honor, yes.
Okay, I've signed that agreement. The clerk is going to email that over to you shortly.
Thank
If
you.
we can look at the grant case next, that would be great, folks.
Judge, there is an offer on that case.
Okay, yeah.
If we could, that's actually how it's going to be for Grant, Ho, and Morgan. There's either an offer or we're waiting on final paperwork to come in. So if we could get resets on those three cases, that would be fantastic.
Okay, are we resetting to Zoom?
Yes, please.
That'll
Okay.
be fine, Judge, yeah.
That's August 26th, unless there's a conflict. Is everybody okay with that date?
That date's good for me.
That
Okay,
date is good for me as well.
okay, I'm just gonna make a note that the offer was made, that we'll check in at the next setting, that we're resetting the pretrial for August 26th, and ask if, and that's on the Grant case, the Ho case, and the Morgan case. Is that right?
That is right, Your Honor.
Yes, Your Honor.
Do either of you have anything that the court needs to address at this time in relation to any of these cases?
No, Judge. Nothing from the state.
Okay, Mr. Swain?
No, Your Honor.
Okay, and let's see, let me just make sure I don't have any questions. Okay, then Mr. Swain, with the thanks of the court, you are good to go.
Thank you, Your Honor. I appreciate it.
Thank you.
Bye-bye.
Bye-bye. Mr. Wolf, is your can you get on screen? There we go. Good morning,
Yes.
sir. How are you?
Great. How are you?
I'm very well. Thank you for asking. And so this is in regards to Robert Rails back. Is that right?
Yes, ma'am.
Okay, let me go ahead and move you over to that meeting with Mr. Matson, who will join you there. Okay, so I was chattering just a bit, but it's important. So I will tell you too that in Texas, what we assume is when a person receives a citation, they are assumed to be not guilty. They make a promise to appear, it's required to appear, but that does not mean that we are presumed to be guilty still. We are presumed to be not guilty. The promise to appear is really, just like if a warrant was issued, but it's a little less invasive and obtrusive. Okay, it helps because arresting people by the side of the road wouldn't be very easily managed. Okay, so you appear, you plead, enter the plea. When you enter a plea, you are really giving your answer, your response to that accusation. And again, as I say, I can't give legal advice, but I can just kind of tell you how things move through a court and what options are available from a Class C court, which can be different, slightly different from higher level courts. We have a few more options, actually. I think that really reflects the fact that we are, the cases here, while they have the same standards and burdens of proof, we see everyday citizens here. And that's not always the case over in the other higher level courts. Most people, what I'm saying is not that the offenses are more serious, they can be, but that most people represent themselves here. And so, the goal is to make it a little easier, a little more friendly, a little less formal. Okay. Just because most of us represent ourselves in these types of courts. when we give our answer, so I can tell you how things move through the court, and I can tell you the options available. What I cannot do is apply the law to your case and tell you what you should do, what you ought to do, the direction you should take it. So I just want to let you know the basic things that are available here and how we handle things. When we give a plea, as I said, we are giving our answer or response to the accusation that was written to us. And if we plead guilty, we're saying, I did this, I committed this offense as charged. And you move that case forward without any procedural questions, without any challenges. And at that point, what the judge, that would be me, does is accepts the plea generally and imposes a sentence or resets for a sentencing date. In Class Cs, we usually do not reset for sentencing because we don't have a probation department to do that kind of assessment and analysis. Okay, so the law says I'm supposed to just impose the fine and expect that you pay it that day. Now, that's not necessarily a realistic thing for all of us. And some folks have challenges. And if you are going to have challenges, if you know you're going to have challenges meeting the obligation of payment, it's a good time for us to talk about it. So if that happens today, I will check in with you about that situation. And just please be assured that I will look at all the things that could be impacting that situation and talking to you about them and weighing that, what we call inequity, in order to see what is a sentence that is a proper sentence in the particular case. Okay, so even though the law has that general rule, assess punishment and pay, there are exceptions to that, and I will impose hopefully an appropriate sentence. I will do my best, level best, to make sure that I'm doing that. So we can talk at that point, and I may have a few questions and you may have a few questions. So we'll discuss it. But that's one option. Okay. If a person pleads no contest, they're just not contesting the charge. It doesn't mean that they're guilty, or it doesn't mean that they couldn't have contested it. It just means that they're not contesting it. They're not admitting it either. So it's a non-admission neutral plea, but it moves you into sentencing. So you need to understand that. That moves that case into sentencing. Like a moment ago, an attorney accepted a deferral and he entered a plea of no contest for his client. And I accepted the plea. I'm going to talk more about what that deferral is in a moment. But the plea was no contest on that case. And we did a sentence at that point, which he had previously read, so I didn't go into the details of it. But I will talk about deferrals in a moment. If you enter a plea, the third option is not guilty. If you enter a plea of not guilty, gosh, I've never heard that before. If you enter a plea of not guilty, I will say then at that point, we're just expecting that case to head toward trial. Those cases are now on this docket, okay? And we all have the right to have 6 people come into the court and pick them from a jury panel and have them hear the case and then make a decision as to whether or not we're guilty. And if we are found guilty, we deal with that. If we're found not guilty, the case is done. We all have the right to engage that process. Most importantly, that process implies that the state prove that case against the person, okay? And they would be required to bring that evidence forward and make that proof. So we all have the right to do that. A jury is what we assume people want to do. That's because the Constitution says that's what we have the right to. If both parties agree to waive that right, then we would move toward a bench trial. The judge of the court would serve in the same fashion as the jury would serve. And in that context, there wouldn't be a jury selection process or a jury here, but the state would still have all the same requirements of proof and burdens that they have. So it just changes who is what we call the trier of fact, who decides what the facts are and what those facts may or may not support. And we shift on a bench docket from the 6 jury members to a judge. Now, I am the only judge of the court at this time, and I would be hearing the case. I'm not saying that to sway you in one direction or another. It's really, I just want people to know who is that going to be. But you have the right to a jury trial. The state has also that same right to a jury. And if they decide that they don't want to have the bench hear the case, then they have the right to say, I'm not waiving. And so if either party, the state or the defendant, you want a jury to hear the case, then the jury will hear the case. If both parties agree, both sides agree, we're waiving that right, then you can set it for a bench docket. And now I will pause and have the prosecution, I think there he is, and Mr. Wolf, Mr. Matson, let's check in on the case of Robert Railsback.
Your Honor, discovery was sent to Mr. Wolf, and there's an offer currently on the table. So if we could reset to the next Zoom date, that'd be great.
Okay, Mr. Wolf, August 26th. Is that an okay date for you?
Oh, that's great, Judge.
Okay, then I will reset and you will get that in your email box probably this day. And we will see you then, okay?
All right. Thank you.
Thank you. You're free to go with the thanks of the court.
Appreciate it.
Mr. Matson, did you have anything before I guess he's gone, but if you have any.
No, Your Honor, I did not.
Oh, I'm still here.
Okay, he's good. You're good to go. I assumed it, but I just did it too fast. I do have attorney from the Tkach firm. That's going to be, sorry, it moved. There we go. Ms. Fairley, good morning. How are you?
Good morning. I'm doing good. How are you?
Very well, thank you. I'm going to move you over to visit with Mr. Matson, and then y'all will come back and visit with me, okay?
Okay.
Thank you very much, Ms. Fairley. Okay. Okay, let me just take a minute and cross out things. So, as I said, guilty, not guilty, no contest. It's they just take you in different directions. And now I just want to talk about what happens if a person is found guilty. And what I would say is I already gave you the general rule of being found guilty and having it go on your record in payment. But let's talk about having things go on the record. What are ways to have a thing go off your record? Okay, so under state law, there are compliance dismissals, things that can be brought up to date and dismissed. That one, I'm allowed to jump in and let you know, hey, this is, if you can just get this up to date, we can do a dismissal if it looks like you can get there. And so I'm allowed to kind of explore that option with you on a plea of guilty or no contest, but I can answer whether it is eligible without a plea if you ask. So ask if you are concerned. Those are things like, having a blinker out, having a light bulb out, having a brake light out. I guess registration in some cases, and in some cases when you can't find your insurance card, but you had insurance at the time of the stop. Those are all things that could be simply dismissed with no fees or with minimal fees. I'm going to assume people want to do that if possible, but I don't see many of those on the docket today. Now, moving violations can be dismissed with a driver's safety course. Driver safety courses, that option under state law, if you qualify to be in that program and you successfully complete that program, you will save about $100 off of your ticket. On a plea of guilty or no contest, you can take a driving safety course if it's a moving violation to keep it off your record, provided you are not a CDL holder. CDL holders are barred from having that option. And I will just tell you that even if we got it through and you got all the way through the process and we sent it down to DPS, because we have to report where a person gains a dismissal through a driving course, we send it to DPS, they kick it back. So there's no sneaking it by. It just isn't allowed under state law. So, we'll try to catch that. But if you're a CDL holder, just please understand that that's state law and I am required to follow it. And, that's just where the status of the law lands. If you have a option like that, though, you want to exercise that option, bring it up with me or with Mr. Matson, and we can kind of explore it with you if you ask about it. And we can look and see whether you might be eligible and whether, if you aren't, if there are any exceptions available to you to make you in that option, to regain that option. But every court, you still have to pay the court costs. Your fine is going to go on hold. And then you pay for your course, you pay for your driving record, you turn that in and you gain a dismissal, and the fine, which was on hold, is just dismissed off of your record. So along with the conviction. So there's no conviction, no fine paid, just the court costs and proof of the class. And now let's talk about the Longborough case. I think I had some paperwork on that. Give me just a moment. I know there is a dismissal on one portion of that case. And Ms. Fairley, we're going to send that over to your office. And I believe that's going to be a completion of that case. Is that both of your understandings regarding this matter?
Yes, Judge.
Okay, thank you both. Ms. Farley, I'm sorry, I said it incorrectly. Ms. Fairley, I apologize for that. Do you have any questions for me as judge of the court this morning?
Well, I don't have any.
Okay, with the thanks of the court, if you're ready, you are free to go.
All right, thank you so much, Judge. Have a good day.
Thank you, Ms. Fairley. Mr. Matson, any questions on that matter?
No, Judge.
Okay, then I am going to keep you moving. Let's see. So your next party is Nigeria Turner. And Nigeria Turner, if you could unmute and get on screen, that's going to help us all communicate just a little bit better. Good morning. How are you?
Good morning. I'm fine.
Okay, I'm going to move you over to visit with Mr. Matson.
Okay.
Okay, thank you. So I've talked about two options for dismissal. The third option is called a deferred disposition. That is a written agreement between yourself and the court and Mr. Matson in this particular case. And the way that would work is there's a period of time up to 180 days, but we usually do 120, where you are actually, we work out payment on the offense. It goes in as a special expense fee. At the end of the deferral, it's receipted into the court's roster. If you've met the terms and conditions of your deferral, which includes payment, not reoffending, not getting warrants, sometimes there's a course due, sometimes not. Sometimes there's a record due. Sometimes there's some document or photo or something that shows compliance. And generally speaking, with the deferral, at the end of the deferral, as long as you've turned in the things that were required, made payment according to the agreement that we have with you on that case, which is written, and don't reoffend, keep your address current, and don't receive warrants, then the case is dismissed. It is a way to gain a dismissal where the first two options may not particularly work. The way that you get a deferral in Class C court is you say to either me or Mr. Matson, I'm pleading guilty or no contest, doesn't matter which one, and I'm seeking I would ask the judge for a deferral. So if you remember nothing else, the word deferral, if you invoke that word, the response is I start trying to work with you to see if I'm approving the deferral, and if I am, then what are the terms and conditions of that deferral? And that's a conversation that we have because it's ultimately an agreement. You can always say, I don't want that. I want trial. But if you want a deferral, you have to ask. That's the important thing to take note of. You're supposed to make that request at the time of the plea. So again, just say deferral, and we move into whether I would grant the deferral or not. And if I do, then that's the direction we're going. And if I say, no, I'm not granting that deferral, then that discussion is just kind of over. But a deferral, again, like I said, for non-moving violations or where you're not qualified, or if something is not a compliance dismissal. Usually penal code violations are where I see the most of those, or on traffic offenses that don't come under the driving safety course option, people can request a deferred. So there's a little more to it than the other two options sometimes, but it is an option. And the main thing to understand about it is that you have to make the request of the judge in any Class C court in Texas. And if the judge says yes, then it's granted and the terms and conditions are sorted out. And if the judge says no, then that's all there is to that. The final dismissal option that we have available in Texas courts, if the court that you're dealing with has a teen court option, then you can have teen court as an option if you are in middle school, high school, in some cases, GED programs. Homeschool is also considered just high school. And then finally, if you are underage, if you are 18, you could have the option of what is known as a pretrial diversion. And that is just a process that requires certain things to take place. There may be requirements of you, probably there would be, just like a deferral has requirements and teen court has requirements. Pretrial diversions have requirements, but procedurally it just works a little differently. And it's an option for young people who are not necessarily in school, but that one is governed by age, 18 and under. Okay, so those are the options, and we're waiting on Mr. Matson and the other side. And you're actually going to see me do a little bit of paperwork, and but I'm here, and you know, if you have questions, remember I can't give legal advice, but just let me know if you have questions. But for now, I'm signing papers for a few minutes, just a couple. Okay, good heavens, I saw you running there. Okay, wow. That's weird. I'm gonna see on Jakaria. Jakaria Adams, I don't think that you're here, but I just want to check if you're here. And I'm just gonna see if the phone number works because I have a feeling she's in an unsteady situation. But weird. It's dialing strangely.
Please leave your message for 76928111005.
Hi, this is the judge from the municipal court calling for Miss Adams. And our number here is 254-298-5687. And just want to check and see if you could call in. We did not hear from you and you were scheduled for Zoom court this morning. I just wanted to visit with you as judge of the court to see what's happening with your community service and your circumstances. So if you could communicate with us, we do take emails, and that is court online help, all one word, court online help at templetx.gov, or you can call in and we would like to hear from you so that we don't escalate the case when we don't need to. If you are having trouble doing the things that have been court ordered, please communicate with us. We might be able to work through that. Thank you. I don't know if it was hers or not, so let's skip. Okay, Ms. Turner, thank you for waiting for us to bring you back over. Let's go ahead and check in on the case with Mr. Matson. I know that, thank you. Okay, so Mr. Matson, it's right now we're at a single charge, an accusation of violating the license restriction. And where are we with regard to that matter?
Your Honor, Ms. Turner and I have reached an agreement for a deferral.
Okay, can you tell me the agreed terms and conditions? And Ms.
I
Turner,
certainly can.
Ms. Turner, I'll check in with you at the end of him talking to me, okay?
Okay.
Okay, please continue.
It's going to be a 120-day deferral, and there are going to be no other requirements other than avoiding citations and convictions during the period.
Okay, and when is payment happening?
Ms. Turner, did you need longer than 30 days?
Yes.
Ms.
Then,
Turner,
Your Honor, I would go ahead.
I'm so sorry. If I break that into two payments and do 30 days in between them, one in 30 days, one in 60 days, that would be sorry, $90.50 in 30 days, and then in 60 days, $90.50. Is that a possibility?
Yes, that's fine.
Okay. Okay. Then what I'm gonna do, or what I can do, is have the clerk send that document to you, and you would print it, sign it, and send it back. Usually we do that through email. I'm noticing a Temple address. We could also do it here at the window if that's convenient. What's gonna work best for you today?
I'll be back in town Friday, so I can come by there. It'll be best if I come by and get the paper.
Okay, I'm gonna extend your case to this Friday. Just in order to give you time to do that. So I'll take a court's extension to July 11th. And then you come to the window and they'll have that available there for you to sign, copy, and we'll go from there. Okay?
Okay.
Okay. Do you have any questions?
No,
Okay. You are free to go with the thank you from me. Okay?
thank you.
Thank you, ma'am. Okay. And so moving forward, Aisha Sheikh, if I could go ahead and have you unmute, and I will move you over to visit with Mr. Matson, okay?
Okay, thank you.
Thank you. So with Miss Turner, she's out of town and doesn't have access to a way to do it. So I'm taking a court's extension to Friday. She'll be back in town and she will come to the window. Okay. I can sign it now. That way she gets her copy. And we'll just pull it back if she doesn't show up and we'll go from there. Corey Larson is going to be coming right up. And I know. Yeah. Thank you. Okay, Mr. Matson, let's see, we were working with Ms. Shake, I believe, is that right?
Yes, Judge, that is correct.
Okay, let's see, let me find that file, I don't know what I did with it. Oh, there it is, okay. Tell me where we are, please.
We have reached an agreement, Your Honor. It's
Okay.
going to be a 120-day deferral with a 6-hour course due by the 60th day and payment of the balance by the 30th day.
Okay, Ms. Shake, is that your understanding of how we're working through the dismissal on this particular case?
Ma'am.
Okay, I can email that to the email that we have on file. I know you're out of town. So I could email that to you and have you print it, sign it, and email it back today. Can you do that?
I can.
Can we use the email that was provided to set up this meeting for today?
Yes.
Okay, then you should look for that in the next before lunch, okay?
Okay, thank you. I appreciate this time.
If you don't receive it, call us, okay?
I will.
It shouldn't be a problem, but if you wind up having to call us, you're trying to reach Miss Stotts, okay?
Okay.
Okay. Any questions before you go?
No.
Okay, then I will accept that as a no contest plea with 120-day deferral, payment on the 30th day, a course due on the 60th day, and when we email you, we'll also email information for how to find the proper class, okay?
Appreciate it. Thank you.
Yes, ma'am. Thank you. You're good to go. Okay. Moving forward, and we're moving forward with Corey Larson. Mr. Larson, you've already unmuted. Fantastic. I'm going to move you over to that meeting with Mr. Matson
Thanks, Your Honor.
on the single accusation of registration.
Thank you.
Thank you. And let's see. Yeah. Yeah, we'll roll with it. Let's see. Exactly. Just, just smile, take a deep breaths, and most things can just be solved right there, you know. Oh, I remember Miss Adams because she said she was originally from Mississippi and was going into the military. And she wasn't able to do her community service because she was moving around so much. She's kind of not entirely unhoused, but there's family. Yeah. And she's I'm gonna look at her financially. Right. But Jesse, they talked to her. I don't know why they didn't just do the paperwork, but
Oh, I've got the paperwork.
okay,
I don't know if they found it though.
yeah, often they don't.
They didn't find on one,
Hmm.
the juvenile.
I wasn't sure what you were asking me. She's 18. Um, and they talked to her, but I don't think we've completed it.
No.
So I want them to reach out and try to see if they can do that, because otherwise they have to reach out and talk to her about community service. We might as well talk to her about teen court first. Okay. Yep. Mr. Miller, Daniel, he's a no-show today. Does he know that he's being revoked? And
Yes,
okay,
that's the whole reason why he went to Ryan.
yeah,
And then Ryan, sounds like Ryan's gonna know.
I don't have that one. Um, okay, there are our no-shows.
Yeah.
We are rolling with it though. We are rolling with it. Thank you. I'm moving Mr. Larson back over. Here we go. Okay, Mr. Larson, Mr. Matson, can we check in and tell the court where we are?
Your Honor, I'm going to move to dismiss this. Mr. Larson provided a registration receipt that was dated prior to the citation he received.
Okay,
It says at the bottom that law enforcement can use it. I
okay,
think there might have been some confusion on the officer's part there.
okay. So no fees are being charged for the dismissal. It's a
That's correct, Your Honor.
prosecutorial dismissal.
That is correct.
Okay, I will sign that dismissal. I'm gonna assume that we'll get that over from you sometime this morning. And
You will.
oh, Miss Stotts has already printed one. She heard me. So
Perfect.
we'll get that over to you, Mr. Larson, pretty promptly.
Okay,
We'll
thank you.
email that. We'll email that to the email that we have on file, but I'm signing it right now.
Thanks, Your Honor.
Okay, thank you.
Thank you.
And you're free to go when you're ready. And Mr. Matson, Douglas Crumnow is here. Mr. Crumnow, if you can unmute and get on screen, that does help a lot. Okay, this is a single accusation of speeding, and I'm going to move you over to that meeting with Mr. Matson at this time.
Yes, ma'am.
Thank you. Folks, I'm going to take a quick moment to run and get some papers, and I'll be right back. I'm not leaving. Okay. Okay. Mr. Crumnow, Mr. Mattson, let's check in about the single allegation of speeding.
Your Honor, Mr. Crumnow and I did reach an agreement for terms of deferral.
Okay,
The terms are going to be 120 days for the deferral period with a driver safety course due by day 60. And Mr. Crumnow, did you need longer than 30 days to make payment?
No, sir.
Then balance due by 30 days, Your Honor.
okay. Mr. Crumnow, normally I just prepare this and email it to you. If you sign it and print it, print it and sign it and email it back, then we're good for today. Can you do that, or do you want to come by the court to do that?
I can do that. Yes, ma'am.
Okay, shall we email it, or are you coming by the court?
Oh, email. Email's fine.
Okay, the email that we used for today's meeting, can I use that email for you?
Yes, ma'am.
Okay, expect that pretty shortly, but I would say before lunch.
Yeah, thank you.
Okay, if you don't receive it somehow by then, give us a call so that we can see what's happened, okay?
All right, thank you.
And then once you send it back, if you email it back, what we'll do is we should reply. If you don't hear from us, again, call and check on it, okay?
Yes, ma'am.
All right. Any questions from you before you go today?
No, ma'am.
Mr. Mattson, any questions on this matter?
None from me, Your Honor.
Thank you. Mr. Crumnow, when you're ready, you're free to hang up, okay? Thank you. And so, Mr. Mattson, let me get Mr. Islam Hanif on the screen. Hi, I'm going to move you over to that meeting with Mr. Mattson.
Good morning, Judge. Thank you.
Of course. Ms. Hernandez, we're coming up. We're almost to your case as well.
Yes, ma'am. Thank you.
Great. Thank you. Thank you. Yes. Thank you. Okay. Are we ready to move Mr. Islam over?
We are, Judge.
Thank you. Mr. Islam, Mr. Matson, where are we with regard to the single charge of speeding?
Your Honor, we have reached an agreement for terms of deferral.
Okay,
It's going to be 120 days with a 6-hour course due by the 60th day and payment of the citation in installments. It'll be, what was that now?
284. Is it 2 payments or 3?
It's going to be 3, Your Honor.
Do we spread those over the 30 days, 30 days, and 30 days?
Yes, please.
Okay. If we did that, the most efficient way would be 3 payments of $95, and I think the last one is less. Hold on.
I believe it will be, Your Honor, 95 at 30 days, 95 at 60 days, and then 94 at 90 days.
Yes, that's what I have as well. Mr. Islam, will that work for you?
Yes, Judge.
Okay, because there's a course required, when we email that to you, we'll include information for how to find a class. The order ought to reflect all the terms and conditions that you've said you would agree to. If I email that to the email that we have on file, can you print it, sign it, and email it back to us today?
Yes, I can.
Okay. Just making a note, and the clerk and I will work on that, Mr. Matson. And that way you're free to move forward. Your last person to visit with is Stephanie Hernandez. Her audio is working. Ms. Hernandez, can I see if your video would work? Oh, perfect. Now you're not driving, are you? Okay.
No,
Okay,
I'm sitting in a parking lot.
I see. Okay. Let me move you over to visit with Mr. Matson.
Yes, ma'am.
Thank you, ma'am.
Hello.
Yes, Mr. Whoops. What's just happened? Mr. Islam, I don't know, somehow got disconnected, but he had already agreed to terms and conditions that are at the bottom, and we can use the email on file, and he can get it back to us today. What?
Great.
Mhm. Yeah, that's why I didn't approve it.
Mhm.
Or, I mean, I needed a prosecutor on that one. It's a lot. It's not like you don't know. If you're going 103, you know that that's not the speed limit.
It's like,
Wow, it's high.
no.
What's he in, a 65? Is that right?
Yeah.
I've seen that on the loop where it's a 55. And I just am like, man, you are creating havoc out there. Whoever you are. I got these. Do you want me to hand these back to you? Cool. Okay, we're having, yes.
It's on last week's, he was a no-show, but just never got, they just got missed in the pile.
Oh, goodness. Okay. Okay. Thank you. Sorry about that. This person sent a plea and requesting time served, but didn't check off a plea, an actual plea. Wow. You okay? Gotcha. Here comes Mrs. Hernandez. Okay. Hello. So let's check in regarding these charges. Where are we?
Judge, these charges are from December and February, and I went and took a look at the officer's code compliance folder on this, and the case has actually been closed out, meaning that the property is now in compliance. So I'm going to just go ahead and move to dismiss.
All three cases?
Yes, ma'am.
Okay. I'll sign those as soon as they come over. And Ms. Hernandez, then I will email those copies to you at the email that we set the meeting for today. Will that work for you?
Yes, ma'am.
Okay. Then with the thanks of the court, you are free to go. And sorry?
I said thank you.
You're welcome. There'll be nothing further after today as far as anything that we have pending right now.
And I just need to go in and pay my court cost fines today.
No, you don't pay anything because he's dismissing.
Okay.
Okay. Thank you.